I'm Matthew Pancook. I'm the director at Seward County Community College Area Attendance School Library, and I would like to welcome you all to our Seward County Community College Area Attendance School Library's Lunch and Library. For this fall semester, this is the third of fourth in our speaker series, The Way We Worked, and this one's going to focus on the legal system here in Liberal, Kansas, and local lawyers. And today we have on our panel our three lawyers at McQueen law firm here in Liberal. We have Jean Sharp, Shirla McQueen, and Kerry McQueen. Jean has been practicing law for 60 years. Kerry has been practicing law for about 40 years. And Shirla has been practicing law for over 25 years. Before we begin, I'd like to thank the Liberal Memorial Library and the Seward County Historical Society for their help in allowing us to hold these programs here, both at the Coronado Museum and here at the Cooper Clark Room at the Liberal Memorial Library. And these programs are made possible by a grant from the Kansas Humanities Council. So let's get started.
Dean?
Why don't you tell us a little about yourself?
My name's Jean Sharp. I'm claiming to be the oldest practicing lawyer in Seward County, and I think probably the oldest practicing lawyer in the 29th Judicial District. I was born in East St. Louis, Illinois on the 20th day of January 1929. I claim this area as my place of residence and the area of which I belong, due to the fact that I started school in the first grade in a one-room schoolhouse in a town named Florence, Oklahoma. It's about 18 miles southeast of Liberal. There's nothing there anymore other than a grain elevator. But when I was young, there was a blacksmith shop, the Masonic Lodge, the school, the church. There had been a John Deere dealer there, a Phillips 66 service station, a bank, a telephone office, and probably some other businesses I cannot recall right now. But they have all disappeared. I transferred to Liberal High School in the 8th grade and continued my schooling through LHS, graduated in 1947. From there I proceeded to go to college, and I obtained a BS degree in government and a minor in economics from Oklahoma University in 1951. And in the fall of 1951, I started law school at the University of Oklahoma College of Law. There were 120 students in the first semester in my class. About half of them were returning veterans of World War II and were 2 to 5 years older than I was. At the beginning of the second semester of my freshman year, there were 96 students remaining. And when I graduated, the number was down in my class to 86. I give you those facts to indicate to you that there has been a big change in enrollments in law schools across the nation. In my class, there was one lady. She was about 50 years old and was a professor's wife. There were no really students other than she, and she was just auditing the course. I have recently been to the OU School of Law and talked with the dean, and was informed that nearly everybody that comes in as a freshman nowadays completes the course. Very few dropouts or failures. And in addition, he stated that about 60% of the students were ladies. By far more females going to law school now than males, and I think that's true across the nation. One of the interesting things about in my class, you got into law school based upon your academic record as an undergraduate student at OU or wherever you went. Today it's based primarily on LSAT test, and I'm told that if you get into a major law school anymore, you've got to have almost 100% correct answers on your tests, or you're just not going to be accepted. In fact, the dean told me in that same conversation that he and I probably couldn't get in law school. From there, upon graduating, I spent 3 months as county attorney in Beaver County, Oklahoma. And I think I had one DUI trial, and that was about it, other than giving advice to the county commissioners as what they couldn't do. They were totally in shock when they found out that they hired a Republican. I was the only Republican in the courthouse at that time. Today it's just the reverse in Beaver County. From there, I might say that Joanne and I got married my senior year, beginning my senior year in law school. She finished her master's degree, and I spent most of that year working on the Oklahoma Law Review. I was the editor-in-chief of the Oklahoma Law Review, and we were doing a special symposium issue on damages. I still carry that book with me once in a while when I'm going someplace, because it really gives you good citations to damage questions. I got called into the Air Force, where I was had a direct commission as a first lieutenant. We reported at Hartsville Air Force Base in Fort Worth, Texas. I tried my first case the same day that I reported, and the doctor had given me 4 shots in one arm and 3 in the other. I couldn't hardly get my arm up to salute the court, but I managed to struggle through. That was my first court-martial case. I didn't really know what I was going to do or what I was supposed to say. There was a lady there who was a court reporter, and she told me, when I break lead in my pencil, you should be on your feet objecting. Something's not right. And that was basic guidance that I got for my first trial. And I was there for about 3 months, and I was in the courtroom every day. These were special court martials where we had a court of 3 to 5 officers or enlisted personnel as they were requested. The maximum sentence that could be imposed would be a dishonorable discharge and 6 months in confinement and forfeiture of all rank that you had, and any allowances that you might have been entitled to as a serviceman. Much time, I was called into the base commander's office and informed that the Korean War was over and that I could go home next week if I wanted to. check with my draft board before making a decision on that. And when I did that, they told me 3 months is not long enough. If you come home, we're sending you back as a private someplace. So I signed what was known as an indefinite statement, which meant that after 3 years, I could submit a request for release. And if the government was ready to let me go, they would let me go, and if not, they'd inform me of that fact, and I would continue to serve. They next sent me to Air Command and Staff School in Montgomery, Alabama, where I was supposed to learn how to try court-martial cases. I'd already tried more than the people who were teaching the course, so we had a great time in Montgomery, Alabama for 3 months. And then I ended up in Altus, Oklahoma. Altus was a small community in southwest Oklahoma that had a air base in World War II that had been shut down completely, and they were reactivating that base. I was the 16th officer to report there, and there was one officer by the name of Captain Bennett who was my superior. He had been a navigator on a B-24 bomber in World War II and had gone to law school, but I'd been out of the law school. He got out of the law school at the same time I did. He outranked me for our service. But anyway, we had our choice of buildings where we were going to have the law office, and we chose the old base operations building. And my office eventually turned out to be in the tower where I could see out every window, every direction, where everything was going on the base. And I spent the next 2.5 years in that capacity. We wrote all the regulations. You couldn't spit on the sidewalk without our knowing about it and deciding whether we were going to court-martial you. We did that because we wanted to try to keep the court-martial rate down. We were pretty successful in that. We tried to get the commanders to give Article 15 punishment, which would be confined to the base for a week, or doing latrine duty or something of that nature. One incident that I enjoy telling about was there was a lieutenant colonel came in with some charge sheets. He wanted to court-martial one of his people, and I refused to accept them. And he just had a fit about that, and he was going to talk to the old man, and I told him to go ahead. And he did. In about 15 minutes, I had called a report to the base commander. And he was a little upset that I turned down those charge sheets. I told him that General May, for some reason that was unknown to me, takes a look at your court-martial rate and decides if it's high, you're not a very good commander. And all I'm trying to do is keep you in good graces with General May. That satisfied him pretty well. And at the staff meeting that afternoon, he told the rest of the group, which consisted of lieutenant colonels and majors, that he had a first lieutenant on his staff, and when he was in his office, he was the lieutenant colonel. When he was out on the base, he would salute you fellows just like he's supposed to. And I didn't have any more problems after that. But we ended up here in Liberal. When I finally did get out, I had to request resignation 3 times. The base commander thought I should stay in the service, and he'd been meaning to talk to me about that. And he was the youngest little jam with general roommate before. But he finally let me go when I agreed to try to find another Oklahoma lawyer to replace myself. And I did that by contacting the dean of law school and found out he was graduating, who might be coming into the Air Force. The first practice I had here in Liberal was in 1956. I joined a firm that was known as Hickey, Harder, Newbar, and Sharp. Hickey was the senior member. He was a jolly good fellow. Did a lot of singing, I think, in his earlier years, because he was always singing some tune in the office. He was a real stickler for detail. Every Saturday when Rex and I didn't really practice law, we came up maybe and checked the mail that we'd leave pretty shortly. Hickey was busy working. He'd give us a report that would tell me how many pages of correspondence I wrote that week and how much money I made, how many paper clips I used, and he was really a stickler. Mr. Lumar was engaged primarily in the domestic practice at that time, and Mr. Harner was a partner in Dodge City who had a general practice, and we got a report from him every week too, how much money he'd taken in and what our share was. I left that firm about 3 years later and joined Vance Hobble, Northern, and Sharpeville. The firm that I'm now in is part of that organization that started in 1926, was it? 25. The thing that's going on down at the office right now is we're trying to pull out all the files that we've been accumulating over the years. And I know that we're buying cardboard boxes, I think, about the truckload. Then we're soon going to have more room than we used to have. I've enjoyed my practice here, and some of the observations about the changes in practices that I would make today is that when I started practicing in this area, all the courthouses were at least 3 stories high, most of them 4, and the courtrooms were always on the 3rd floor, where the clerk of the court had her offices and the judge had offices. That was before there was any air conditioning, before elevators, and all of the courtrooms in the 29th district and even in Texas and Beaver County, Oklahoma, were of similar design. The result was in July and August, there weren't any trials. There were practically no hearings. You couldn't find a judge. He was in Colorado or someplace. And that made it pretty relaxing to practice law around those 2 months. But that all changed about the courtrooms became air conditioned. Now we have trials year round. And those old courtrooms still remain. I think I tried the last jury trial in the courtroom of the old courthouse in Stewart County, which was located in the block where the city hall used to be. And what I remember most distinctly was in that case, I had handed an exhibit to the jury panel, and they were handing it down the row, and somebody dropped it, and there was a space about that wide between the wall and the back of the jury panel, and the exhibit went clear to the first floor. We had to go down there, retrieve it, bring it back to the trial. So they really did need the courthouse. And they've then replaced it with the one that's up between 3rd Street and 4th Street. And now we've replaced it again. The practice of law has grown a lot in Seward County, but the number of lawyers hasn't changed a whole lot in the last 40 years or so. I think maybe there might be 25% more lawyers now than there was when I first started. But when I first started practicing here, there was only one clerk in the court, and she had one assistant, and most of the time they were playing canasta. Now I don't know how many we've got, but I'll bet it's over 10 people in the clerk's office. And it's in many different rooms in the old courthouse. So there's been a lot of expansion there, and they had the jail. The jails used to be on the 4th floor of those tall buildings, where it was really hot and more difficult to escape from. Now they're air conditioned. They're generally on the ground floor of the new courthouse. But there's a lot more cells than there used to be. I'll talk a little bit about court reporters, or shorthand reporters. When I started practicing, all of the court reporters were shorthand people. They made scribbling what it looked like on a small pad that they carried with them. And it could keep up with the fastest talker in the courtroom. Didn't have any problem. I think shorthand was commonly taught in most high schools in those days. And with the advent of recording devices, those courses were dropped. And along about the early 50s, there was a shortage of shorthand court reporters that could do a good job. And the service, and I think some of the civilian courts went to what was called a steno mask. There's a few of those still in existence and used today, but it was just a mask that a person put over their face, and they repeated everything that they heard. And it was recorded then on a recording device. Just the whole purpose of the mask was just to keep the noise down from their talking in the courtroom. And from there they developed a steno machine, which looks like about half the size of a typewriter, has three or four rows of keys. I think it operates somewhat like the kids do on their telephones now with texting. That's what's in vogue at the present time. But in the past few years, there's been a lot of video used in taking depositions. One of the rules of appellate courts that have been in existence long before I began practicing was that appellate courts do not review the findings of fact made by a court in a bench trial or by a jury in a jury trial unless there's nothing in the record that would substantiate the existence of that kind of a fact. And the theory for doing that, or having that rule, was the court observed the witness when he testified, and so does the jury. And they're in a lot better position to judge the veracity out on their forehead on cross-examination and things of that nature. And the trial court could, just reading the print and the record. I think we're not too far away from doing away with court reporters, and we're going to have videotapers in all the proceedings in the courtroom are going to be videotaped and placed on a record, sent off to the appellate court. And I'm wondering what they're going to do about that law. I think they may change it because the courts have an inherent interest in the facts that are presented, and they always seem to want to arrive at their own conclusion as to what is correct from what the witness stated. So I'm thinking that in the future sometime that law is going to be changed. I want to comment one more thing, and that's about the cost of litigation today. When I first graduated from law school, Kansas, Oklahoma, and most states followed what was called code pleading. And that meant when you filed a pleading, you had to state the facts on which you were relying in sufficient clarity that the court can determine whether you have stated a cause of action, and if you fail therein, the court was apt to sustain what they call a demurrer, which meant that that was the end of the case. At the same time, the federal courts were following a different rule, and that was called notice pleading. It was intended by the federal court to make it easy for non-lawyers to file a lawsuit if they wanted to do so. And under notice pleading, you really didn't have to say much other than, I claim you owe me some money. And then it was your duty as a defendant to find out what the facts were by discovery. And that has led to a very dramatic increase in the cost of litigation. And it's gotten so bad that the average person on the street really can't afford to get involved in any kind of lengthy litigation. And it really kind of took some of the fun out of being a lawyer. I liked it better when we had what I call trial by ambush. You just got your witnesses and went to the courthouse, and they brought their witnesses, and we put them on the stand, and we tried to impeach them by our clever questions. And it's taken all of that out. Now when you go to court, you're supposed to know what all the facts are. The only thing that you're worried about is what the law is, what the judge is going to do. I don't know where my not the way I think it should be. You're next.
I'm Kerry McQueen, and contrary to the introduction, as of January, I have been practicing 48 years. I'm in my first job out of law school. In late 1961, Gene Sharp was on campus at Fort Spring University School of Law in Topeka, and I interviewed with him. And shortly after that interview, Jamila and I traveled to Liberal and met Gene's wife and Gene's partners, and all the lawyers in Liberal and in Guymon and in Beaver, Oklahoma. And we were very fortunate to be offered the opportunity to come to Liberal and practice. What got me to that point was I was born and raised in north central Kansas in Phillips County, a farm boy. Attended a school, I had 11 in my graduating class. Attended Fort Hays State University. Met my wife Janelle, a native of the adjoining county, Smith County, and we were married after sophomore year in college. My intentions always have been to be naval aviator. As a matter of fact, I was in the naval AOC program. But unfortunately, while in college, I was wrestling and kind of last up some metabolism issues. And when I graduated and was getting ready to take my flight physical, I didn't pass. Janelle still had a semester to go at college. I was given a slip of paper to take to my family doctor so many months on down the road to run these blood tests again. And I had a decision to make. What am I going to do? I'm still wanting to be a naval aviator. And by this time in life, your entrance into law school was based upon your LSAT grades. On a whim one Saturday afternoon, one Saturday, I took the LSAT examination, and at the end of the examination, for the, I think, $15 it cost us to take the exam, our law school results could be sent to 3 law schools. It occurred to me, I didn't know where the law schools were. And one of the people that I talked with told me that there was Washburn, there was Denver University, and there was Kansas University. And I said, we'll send the results there, and I got an acceptance from Washburn University. Because of that semester, that between the time I was initially rejected for military service and the time I was admitted to law school, I was a January entrant into law school. That's why I had January graduation. Took the bar examination in late January or very early February, and started practicing here in Liberal, Kansas. Gene talked a moment ago about trial by ambush. My first trial was within a month after I was out of law school. Gene was preparing his case for defense. I was tagging along, carrying his briefcase, figuratively speaking, helping interview, and by that I mean I'm listening to the interview of the witnesses, getting a sense of the case. And I'm going to get to go to trial and watch Gene Sharp try a lawsuit, so I knew what I needed to do. The morning of the trial, I get a call from Gene Sharp saying, Kerry, I'm sick. You're going to have to go try this case yourself. So when he talks about trial by ambush, I'm not certain whether he's talking about ambushing the other side or ambushing his co-counsel, but that was my first experience in the courtroom. There have been a lot of changes in law in both Gene's and my practice. The law has evolved a lot. Principles of law have evolved in the last 40 or 50 years. Many times this evolution in the law is because there's an evolution in society, not just in the social aspects of society, but in the commercial aspects as well. For example, the principles of what constitute a contract, offer, acceptance, and consideration, those principles are not changed. But what we've seen evolve are things like what will constitute an offer, what will constitute an acceptance, what is an adequate consideration. That would be an example in commercial law. Another area that we've seen a lot of changes in is in what's commonly referred to as tort law. When I started practicing law, there was a doctrine of contributory negligence. If someone accused another of doing something in a negligent manner that caused that person harm, that person could seek recovery for their harm. But if the person accused could prove that that one person, the person making the claim, was guilty of any percentage of negligence at all, that small percentage of negligence would entirely bar the recovery of the person making the claim. That's now changed to where we've gone to a concept of comparative fault, where you would have the fault of the parties involved in litigation compared. And as long as your fault did not exceed 49% of the fault, you would be entitled to some recovery. This list of changes literally goes on and on and on. A lot of the changes have resulted because of legal think tanks understanding the complexity of our commercial environment and the complexity of our social environment, have spent a lot of time in attempting to develop uniform laws so that the law on a particular subject in New York would be the law in any other jurisdiction that has accepted or adopted that uniform law. Living where we live, so close to Oklahoma, so close to Texas, so close to Colorado and New Mexico. A lot of the clients and lawyers in communities that are so situated are faced with advising their clients based upon a law in a different jurisdiction than where they're actually licensed to practice. And so you've got the uniform laws that have created substantial changes in the law. And I don't mean to downplay those because those are. I want to thread back parenthetically to a comment Gene made about how many survived from his freshman class. As a January entrant into law school, I had 32 classmates. There were 11 of us that survived. Now, that's not to say that 22 flunked out of law school. That would be incorrect. But it would mean that 22 found that they didn't like the course of study. Something happened in their life that prevented their continuation. But there was commonly understood that you would lose a large percentage of that entering class when you started law school. Likewise, the numbers in terms of gender diversity at the time I went to law school were not a whole lot different than when Jean had gone to law school 11 years before. Very few ladies enrolled in law school, and even fewer of those graduated. What made me think of that is technology. Shirla came along, been out 25 years, and she kind of was part of that era in law education where technology was just starting to come to the surface. And I'm telling you, the technology that we have now has changed the law dramatically. In the method that we research the law. And believe you me, even if you've been practicing law as long as Jean has, or I have, or Shirla, you're always looking at the law. You're always looking to see, has there been any changes in law? Has there been anything that's happened? Maybe not in Kansas, but have they dealt with this situation in Colorado or Washington State or California? So you're dealing with the technology explosion in terms of research and methods of communication. I can understand why the United States Postal Service may be suffering financial hard times. There's so much communication that now goes on electronically. It has broadened the scope of the law from the standpoint that when I first started practicing law, we would prepare a case for trial. We typically would rely exclusively on the decisions, well, the statutes of the state of Kansas or the decisions of the Kansas Supreme Court. With the explosion in research, the technology is allowed in research, it's not uncommon to present a brief or to read an opinion from the appellate court where the laws in other jurisdictions, there's as many citations to laws from other jurisdictions as there would be from Kansas appellate courts. The other change that I've seen that I think is significant is, and it has a little bit to do with what Jean was talking about on the court report, but it's the court processes themselves. When I started practicing law, we had to file a petition or an answer or a pleading of some sort. Typically that pleading would be mailed to the clerk of the court, or in our case here in Liberal, we'd walk it across the street to the courthouse, have it file stamped, and serve it on the other parties by mail. We're in federal court now looking at electronic filings. We'll soon be looking, we're looking at some electronic filing now in Kansas courts, and it'll become, I think, a matter of course that all the filings will be done electronically. On the court reporters, and I am old enough to still remember the shorthand writers, and not breaking the lead pencil, but it was true. When you got from the court reporter, you knew you better be making an objection about something. I think before we go completely to digital reporting, we'll see some evolution in that technology as well. Gene talks about the voice writers. We're back to, because there's such a shortage of court reporters, we're back to certifying voice writers on the Kansas Board of Blair County, or court reporters. It's yours.
Well, my name is Shirla McQueen, and Kerry is my father. I'm a liberal Kansas girl. I mean, we moved here when I was very young, when Dad took the job with Gene and his partners, and so I grew up here in Liberal. I graduated from Liberal High School, and I went to West Texas State University, which is now West Texas State A&M in Canyon, Texas. I received my Bachelor's of Business Administration in 1984. Growing up with a father who was a lawyer, and seeing how hard he and his partners worked. I mean, nights, I remember Dad always being home for dinner, but I remember him almost always going back to the office after dinner. And I know that he wasn't alone. I think that was typical for the people who worked in the firm. So I saw how hard they worked nights, weekends, on holidays, working while we're taking vacations, checking in with the office. I knew that being a lawyer was just not at all what I was interested in doing, and so I was a business major. But I get to my junior year of college, did not have any clue as to what I was going to do with this marketing degree that I was getting. And so Dad said, well, why don't you take the LSAT and see about going to law school? And I took the LSAT and did well enough on it that I was accepted to the University of Kansas. It still was not my intention really at that time to ever be a practicing lawyer. What I wanted to do was get my law degree and a master's in business administration and maybe go into law office management. I had been accepted to the business school at Texas Tech, but waitlisted for law school. And at KU I was accepted to law school but waitlisted on the business school. So, to get my MBA. And so I decided to go to KU and get my law degree. And once I started the coursework, I thought, you know, this really does seem fascinating. And I didn't want to take any more finance courses. And so I abandoned my MBA dreams and decided to be to just go ahead and to be a lawyer. I didn't end up in Liberal right away. I don't know if I had a chip on my shoulder or was rebelling against my parents or what the deal was, but it was really important to me that I sort of forged my own path. I didn't want anybody to think that I came back to Liberal and had all of this handed to me. Although I do remember either right before or right after I was taking the bar exam, getting a call from Gene telling me that there was a job open here if I thought I wanted it. And I didn't have a job lined up at that point in time, but just really knew that coming back to Liberal at that time wasn't what I was interested in. So I thanked him for the offer and took the bar exam and went to work for the state of Kansas. I worked for the Corporation Commission in regulatory and environmental law, starting in Topeka and then moving down to Wichita. And after practicing for 4 years with the KCC at the end of Governor Hayden's term, I decided it was probably time for me to move on, to go to work for a corporation that had been in front of the KCC. So I had worked with them from the administrative agency side. And I probably would have taken that job if they would have sent me to their headquarters in Houston, Texas, which I thought sounded just very exciting. But instead they told me that they'd be sending me to Independence, Kansas, and I thought that sounded less exciting. And so while I was trying to decide what I wanted to do, I ran into, and I don't even know if Dad and Gene know this story or not, but I ran into Gene's son Rex at the law library in Sedgwick County, and Rex was practicing law here at the firm at the time. And Rex told me that I really needed to think about coming back to Liberal, that the attorneys I can't, New Bower Nordling, so I can't even remember what the firm's name was at that time. But the attorneys with this firm were some of the best and brightest that Rex had ever had an opportunity to work with. And he'd come back to Liberal after having worked in Houston with a large firm. And what Rex said was that, you know, I would learn how to be a great attorney if I came back. I don't know if I hit the great attorney part, and if I didn't, that failing is all mine and not my mentor's. But he was right. I've been here for, well, I've been practicing for 25 years, but I came back to Liberal in 1991. And I can tell you that there is not a day that goes by that I still do not learn something from Jean and Kerry and all of the other people with whom I practice in my firm and in other firms. While I never practiced in a large firm in a city, I had an opportunity working for the Corporation Commission to witness attorneys who did work in larger cities and in larger firms. And they didn't seem to be all that collegial, quite frankly. There was really a cutthroat mentality. Coming back here to Liberal, from the very beginning, if there wasn't somebody in my firm who could help me out with a question, you know, I could call Jim Yoxel, and he would be happy to help me out. Working in a small community such as Liberal has just really been a blessing, because there are, I mean, everybody just always seems very willing to help out, and I'm just not sure that you have that exact same type of atmosphere in the large firms and in the large cities. I have no idea how many people were in my law school class. I know that about 50% of them were women. And when I moved back to Liberal, I think I was the 4th woman lawyer at the time practicing here in Liberal, and I was trying to do a head count. I think today there are 8. Although we sort of have a rotating crop here. So we've had a lot of women attorneys at various times since I've been back. Before I came back to Liberal to practice law, I had an opportunity to work here one summer as a law clerk. And the summer I worked here, I think it was the summer of '85, the firm still was working on selector typewriters. I think we even still had a couple of manual typewriters. And if the secretary made a typo, they were retyping, you know, the entire document over again. When I worked for the state, they didn't provide secretaries for us, so we did a lot of our own work. And when I came down to practice law, I was asking where my computer was. Now, in '85, we were also fighting over whether to spend money to get a fax machine. You know, the summer of '85. That was the one big dispute I remember the attorneys having. So when I came back in '91, I was asking, you know, where the computer was. By this point in time, we were on a mainframe computer system. And I asked if, you know, if the firm would get me a computer, and I was told that clients weren't paying me to be my own secretary, and nor would the firm, and so there would be no computer for me. And I went out to Walmart and bought a computer and brought it into my office. Wasn't connected to anything, but just the lack of technology at that time was a little bit unsettling to me. Since then, and it's certainly not been recent, it's been evolving. Every attorney in the office has a computer. We do a lot of our legal research, as Kerry mentioned, on the computer. We have clients who have gone completely to a paperless environment. And while it may take a couple of retirements at our office, I am committed to trying to work toward a paperless environment as well. But while I don't have the experience or while I haven't noticed as many changes in the actual practice of law as Jean and Kerry have, you know, what I have noticed in my 25 years has been the explosion of technology. It certainly, well, instead of those days where, you know, you're down or the nights where you're down at the office working after dinner or on weekends, technology allows me to practice remotely. I can, you know, access every file in the office, my calendar from home, which which makes it easier and more convenient for me to spend time with my family, but still make sure that I'm not neglecting what my partners expect of me and what my clients expect of me. And ultimately trying to, I think ultimately trying to find a way to best serve our clients is ultimately what we're all about. Jean told me, I think within my very first week that I came down to practice, that if I would take care of my clients would take care of me. And ultimately, that's what I think all of us try to do on a daily basis, is find a way to best and most efficiently serve our clients. So.